The topic of legal writing is, quite interesting. One of the reasons why I think it is interesting is that no one has paid attention to it. Although we are dealing with legal issues on a day-to-day basis, but how do you present those legal issues when you write about them is something that we have not paid attention to. So I'm very glad that this topic of legal writing has been taken up for discussion today. I hope there will be many more of such discussions so that we can bring some sense into issues of legal writing, some of which I will highlight during my presentation. Now, I have classified legal writing into 5 different categories. The first is legislative writing. How do you draft laws? That is legislative aspect of legal writing. The second is judgments. How to write judgments? What are the requirements of judgment writing and so on. The third is professional legal writing. Drafting of contracts, drafting of complex documents. Mr. Jyoti Sagar will be addressing you on this issue also. The fourth is academic writing, that is commentaries, research papers, and so on. This is also extremely important, and I'm very glad to say that there is a lot of academic writing, academic legal writing that is coming out in the country today. And there are many young lawyers, including law students, who are doing a lot of academic legal writing. But Professor Ranbir Singh will, I'm sure, deal with this topic at much greater length. And the fifth and final category that I have, I would call it miscellaneous legal writing or other legal writing. So you will have articles, which are written in the newspaper, for example, on some issue, or you have some journalist expressing a point of view. You could have something very important like a will, which is written by a person. It can be written by a person, and it is valid as long as it is, witnessed by 2 adult persons. So really, it's not such a complex subject, but I think we in the legal profession have made it complex and given the word legalese to the dictionary, something which only lawyers can understand, other laypersons cannot understand. So I will come to the first category, that is legislation. Now, legislation is of different kinds, in the sense that you have primary legislation, that is laws made by Parliament. Then you have subordinate legislation, that is rules which are made under the law. So the law gives power to make rules. And you have regulations which deal with actually procedure and how much of fee has to be paid for a license, things like that. But all these are would fall in the category of legislative writing. Now, this is very important because there are 2 or 3 things that we must understand. One is that the legislation has to be simple. It is something that you and I and anybody else on the street can understand. If the law is complex, then it's impossible to follow it. I will not be able to understand what the law is, and therefore, I might fall foul of the law, and in that event, I will get some punishment. So the law has to be very clear, and the intention of the legislature must be made very clear in the law itself. As judges, as lawyers, we try to find out what is the intention of the legislature. Why has the legislature enacted a particular law? Now, it's very difficult to find out, because if in a parliament, for example, where you have so many members, you will get so many different viewpoints. on a particular law or on a particular section of that law. So how do you find out what is it that Parliament intended? One way of finding out is to look at the statement of objects and reasons, which is given when a law is placed before Parliament. But that by itself will give you a broad idea of this is what the legislation intends to do. But what does a particular section intend to do? Why is that section there? Why are those words over there? So this is, something which is very difficult, and a lot of time is actually spent on lawyers arguing what is the intention of the legislature, and of judges trying to find out what is the intention of the legislature and then putting it down in a judgment. So really, judges and lawyers are guessing the mind of the legislature, which is something very, very difficult. So that's why there has to be a need for a detailed discussion on what the law is, what is it that the legislature intended, whether it's Parliament or whether it's the state legislature. There has to be a greater discussion in the law. One of the ways of understanding the law, it was laid down as a rule many, many years ago, a couple of 100 years ago, something called Hayden's rule or the mischief rule. Now, what that, it came out of a judgment. What that lays down is, what was the law earlier? Right? So if there was no law, what is the common law that was in existence earlier? What is the mischief that is sought to be controlled or that is sought to be resolved? What is it that has happened that has made you to legislate? Third, what is the remedy that is being provided by the law? Is there some administrative remedy, or is it some judicial remedy? Is there an appeal, and so on? And fourth, what are the true reasons for this remedy? So if you had a law earlier, why are you enacting a fresh law? Is there something that has gone wrong with that law? What is the mischief that you're trying to cure? What is the remedy that is available? What is wrong with that remedy? Why are you bringing in a new remedy or a modified remedy? These are all questions that arise during legislation. I would like to give you two examples about simplicity and the choice of words. The laws that are enacted in India follow a particular pattern. There was one departure, and that departure was when the Arbitration and Conciliation Act was enacted in 1996. The idea was, let's make it simple. After all, who are the persons who are going to go in for arbitration? It's only ordinary people, small corporations, maybe big corporations. So let's make the language simple. But in that simplicity, it has caused such a huge amount of complication that the Supreme Court had to sit in a bench of 3 judges, then they had to sit in a bench of 5 judges, then they had to sit in a bench of 7 judges to try to understand what is the law. So really, in the process of making the law simple, the Arbitration and Conciliation Act has complicated the entire thing, and it has led to so many amendments and so many judgments, so many interpretations. So one has to be very careful in the choice of words. So while simplicity is a good goal to achieve, the choice of words is important. In this regard, I would like to mention about a law which said that vehicles are not allowed inside a park. Now, what is the definition of vehicle? That was not given in the law. So if somebody takes a pram with a baby or an infant, it's a vehicle as far as the infant is concerned. So does it mean that you can't take a pram inside the park? Today, you have kids on skateboards. They travel from one place to another if the road is smooth enough. And if they take a skateboard in the park, is that prohibited? It's a vehicle of movement. So the choice of words becomes important. Simplicity and the choice of words, these are very key issues that arise when you're drafting legislation, apart from, the hidden rule or the mischief rule that I have adverted to. Second is about judgments. That is the second category. For whom are you writing judgments? If you ask a judge, are you writing a judgment for the lawyers? Are you writing a judgment for the litigants? Are you writing a judgment for the parliamentarians who have made the law? For whom are you writing the judgment? I think that the judgment must be written for the common person, so that everybody knows what is the law. So the judgment also has to be simple. It has to be in easy language, which you and I can understand. And that is one of the reasons why the Supreme Court is now insisting that judgments of the Supreme Court should be translated in different languages. Why? Because it is written for the people. And the people should be able to understand the judgment. If it is written in English, it should be simple English. It can be something which it should be translatable into regional languages, which is what is happening, so that persons who do not know English can understand the judgment. Now, we've had, strange instances of judgments being delivered. There is an article which I would, request all of you to read. It's called Judgment by Thesaurus. Now, a judge of the Supreme Court wrote this judgment which nobody could understand. The first sentence in that judgment was about 170 words, right? No full stop except after 170 words. The second sentence was equally long. Now, how do you understand a judgment like that? I mean, I think even judges cannot, sometimes understand those kind of judgments. I remember being in court one day when a bench was being presided over by Justice H.R. Khanna. Justice Krishna Iyer was a great judge. I mean, there's no doubt about it. I don't think anybody has any doubt about it. But the language that he used was somewhat complicated. But he wrote very well. So even if the language was very complicated, you could somehow or the other make sense of it. Somebody cited a judgment before that bench. And the presiding judge asked, who has written this judgment? So the lawyer said, this has been written by Justice Krishna Iyer. So the judge remarked, in that case, whatever you say, I will accept it. I don't have to read the judgment because I will not be able to understand. Right? So the language has to be simple. Now, you can use big words, but why? Benjamin Franklin says, if you can use a small word instead of a big word, please use a small word, so that people can understand it. But at the same time, it should not be so simple that it becomes, a bit of a joke.
Meaning is lost.
I will give you two examples. One is somebody who was asked to pay a tax. He came to court and he told the judge, he said, as God is my judge, I do not owe this tax. So the judge passed a judgment in which he said, he is not, I am, you do. So, I mean, the judge conveyed whatever he wanted to, but it becomes a bit of a joke in this manner. There's another one where a lawyer wanted to distinguish the facts of one case from the one that he was arguing. And after having argued, the judge wrote, he didn't, we couldn't, judgment affirmed. So he didn't distinguish the facts, we couldn't distinguish it, so judgment affirmed. 5 or 6 words. That's not, how judgments should be written. I mean, these are, extreme examples, but they're there. We've had to deal with judgments which are absolutely unclear. I've had to deal with one of those in the Supreme Court. I was reading it in late evening. I couldn't understand it. So I thought, let me read it the next morning when I'm fresh. I read it the next morning. I still couldn't understand it. When I went to the court, I asked my brother judge, I said, have you understood what is written in the judgment? He said, I have not. We asked the lawyers, what is the judge trying to say? And they very frankly said, we've not understood it. One of the lawyers actually said that I contacted a friend of mine who's a professor in English, and even that professor in English couldn't understand it. Now, what is the use of a judgment like that? We had to set it aside on the ground that it is incomprehensible.
Yeah.
Unfortunately, that judge has not realized that he should write comprehensible judgments. Recently, about a month or 2 months ago, he wrote another judgment, which the Supreme Court could not understand. So, just because you have this learning, big words, doesn't mean you have to put them into your judgment, which nobody can understand. There has been an instance in the Supreme Court. Justice S.V. Sinha has, in fact, begun his judgment by saying that a particular judgment is so unclear that a bench of 5 judges has been constituted to interpret that judgment. He said it's the first time it has happened in the history of the Supreme Court. So, judgment writing is an art. It is for the benefit of everybody so that people can understand it. If judges of the Supreme Court are unable to understand judgments, what is the use of that judgment? Okay, so simplicity is important, but not the extreme kind of simplicity, the 2 examples that I gave you about. The other problem with judgments is the use of Latin phrases.
Yeah.
Judges use Latin phrases left, right, and center. Latin is a foreign language to us. English is a foreign language in a sense, but Latin definitely is a foreign language for us. Even for the British judges, it's a foreign language. So you have, all kinds of maxims, as they say, in Latin, which are, peppered into judgments. Res ipsa loquitur. It means the thing speaks for itself. Now, what thing speaks for itself and what does it speak? We don't know. But it's nice phrase, res ipsa loquitur, so we use it. So you have all these Latinisms. Now try to imagine, a converse situation. If you are writing something in Hindi and you start, using Sanskrit words, Sanskrit is a language that is ours. It's not a foreign language for us. If you start using Sanskrit while writing, a judgment in Hindi, district courts write judgments in Hindi, who will understand it? I mean, none of us are literate in Sanskrit. Very few. There are people who are literate in Sanskrit, but hardly anybody is literate in Latin. So why should we use these Latin phrases? I think we have to, get rid of them. So again, simplicity, short judgments. You don't have to write judgments which are 200 pages, 300 pages. Avoid Latin phrases and use simple English. The third category, in my view, is that of professional legal writing. Like I said, Mr. Jyoti Sagar will speak about that. But just a few words on this. You have contracts and other documents, legal documents, which are drafted day in and day out by professional legal lawyers. Again, clarity is required.
Highly confusing.
I've had to deal with complex commercial contracts as an arbitrator. Now, one of the essentials of the contract is that both the parties should be on the same page. They know what they are signing, they understand what they are signing. But most of the disputes that I've had occasion to deal with as a judge and now as an arbitrator is on the interpretation of a particular clause in a contract. So one party says, this is how I interpret it. The other party says, no, this is how I interpret it. Now, where is the meeting of minds? If two parties say completely different things about the interpretation of an article in a contract, there is no meeting of minds. Now, if there is no meeting of minds, you could very well argue there is no contract. So this, is something which has to be clear, because of the language that is used in some of these contracts is so complex that it becomes very difficult to understand what are the parties trying to say. One extreme example that I will give you, which is quoted, quite frequently on topics of legal writing, how a lawyer would write a sentence: I give you this orange. That's 5 words. I give you this orange. If you ask a lawyer to write it in that legalese, that lawyer will write. I will just read a part of it because it's very long. Know all men by these presents that I hereby give, grant, bargain, sell, release, so on and so forth, my right, title, and interest in this chattel, otherwise known as an orange, together with skin, pulp, pip, rind, seeds, and juice. That's how a lawyer will say, I give you an orange.
Orange.
Now, if somebody comes to you with a sentence like this, what sense can you make out of it? I've given an example of an orange, but then it could be anything, some machine, some maybe a book, with words printed in it in black ink and this, that, and the other. Instead of saying, I'm giving you a book, you write a big, long thing, paragraph. So these are, issues of simple English and English that you and I can understand. Lawyers tend to use what are called lawyerisms. I think we should avoid those. Things like hereinbefore, hereinafter, aforementioned. Do we need these kind of words? Said. The said street, the said man went on the said street to the said house. I mean, I'm sure it can be made much simpler than just using the word said so many times in one paragraph. So these again, I'm sure Mr. Sagar will expound on this. But again, the point is of clarity, of being understood clearly by everybody to whom it is being addressed. The fourth category is that of academic writing, which, like I mentioned earlier, commentaries, research papers, thesis, case studies. Professor Ranveer Singh will, I'm sure, speak on this. But the audience in this category is different. You're writing a thesis for a particular purpose, academic purpose. So only academics are going to read that. It's not the person on the street who's going to read it. So really, some of the, of course, simplicity must be there. And some of the, a little bit of play in the joints, so to speak, must be given to these academics when they're writing these kind of, thesis and research papers and all that. Because like I said, the audience is different. So maybe a little bit of leeway can be given, but clarity must be there. It should not be so obtuse that even an academic doesn't understand.
Yeah.
So if judges write judgments which judges cannot understand, there is no reason why academics should write thesis which academics themselves don't understand. It has to be clear what is the point you're trying to make, what is the central point of your thesis, and how are you expressing it. This is very, very important. Then the fifth category is that of other legal writing, which is articles. Journalists and reporters, they write day to day on legal issues, that this is what happened in this case, these are the broad facts. You have persons who are filing PILs, public interest litigation, in person. They must also be clear about why are they filing this public interest litigation. It must be clear so that the judges can understand. Now, if that person writes something in a language which nobody can understand, judges cannot understand, the purpose of the public interest litigation goes away. And this is one of the reasons why the Supreme Court has said we will entertain letter petitions. So you don't even have to write these, big petitions which run into 40, 50, 60, sometimes 100 pages. Lawyers tend to do that, huge, petitions with the evidence in it and all kinds of things in it other than the facts. You have a will which anybody can write. You don't have to go to a lawyer to write a will. Anybody can write a will. Now, if that will is written in some complicated language, how is it going to be executed? Who are the beneficiaries? You have to be clear about that. You can't write a will and say that, after my death, let people try and understand what I've written in my will. So, if these kind of documents, a will is a very, very important document which survives a person. If an important document like this can be written by a lay person, by the man on the street, and which can be understood by everybody else, why is it that most of the other kind of legal writing, judgments, legislation, so on and so forth, cannot be written in that simple language? So I'll just wind up by, just summarizing a few broad rules. One is that the audience that is being addressed is important. So you have the audience of the laypersons, the man on the street, the woman on the street. You have academics, two broad categories. Simple English runs through the thread, all five categories of legal writing. Avoid big words, avoid Latin, avoid, long sentences, long judgments, long articles. There has to be clarity. The definitions have to be clear so that people understand what you are talking about. Then examples should be given. Very easy, very good. The IPC, if you go through the IPC, they have illustrations. Why? So that the section can be understood. Evidence Act, they have illustrations. Contract Act, illustrations in that also. Why? So that it can be understood. So there is absolutely no harm. In fact, I would say that it should be encouraged that in legal writing, examples should be given. It could be through a footnote, it could be through an annotation, it could be through an explanation, it could be through a comment. But this will be extremely helpful to understand what the author is trying to say. Finally, 2 points. When you're doing legal writing, your first draft is not always the best. There is a professor of English called Professor Raymond. He says that great authors, renowned authors, they write their book maybe twice, maybe 3 times until they are sure about what they want to convey. He says he has come across an author who has written the same book 8 times, draft, and the 8th one he has approved. So you have, these people who first draft, they don't accept. That's what makes a good author also. The second example I would like to give is that of one judge called Justice Holmes of the United States Supreme Court. He wrote very short judgments, very clear, very short. Somebody asked him that, how do you manage to write such clear judgments and such short judgments? In such few words, you write so beautifully. He said, I'm an old man, so I stand up and I write by hand. So either my legs get tired or my hand gets tired. So I have to be brief.
Brief.
And that's how his judgments are very well received by everybody. So these are some issues that I just wanted to place before you for legal writing. Thank you very much for your patience. Thank you.